And everybody, we are, I think most people that are in, and we are in recording mode, so we can go ahead and start. I'm Greg Siskin. Thanks for joining us this week. This is our second Zoom video conference, and hopefully it'll become something that's a permanent staple that we do. I'd say now that everybody knows how to use video conferencing, it's a nice new tool that we can take advantage of to communicate with folks. The way we have decided we are going to format is we will focus on, we'll present the week's news, the major developments at the top of the hour, and then we'll concentrate on a specific subject for the call, and then we will take your questions as well. We keep having people coming in. Okay, I'm admitting more. Very good. So this week we're going to be talking about not the most pleasant of subjects, but basically how the economic downturn affects immigrants, in particular how layoffs, furloughs, hours reductions, salary reductions, and similar changes affect people in various states of their immigration process. I asked Jason Susser to join me this week because Jason is one of the business immigration lawyers at the firm. Jason and I have just finished drafting a book on immigration options for entrepreneurs, which will hopefully be out later this summer. And he sees these issues, as do I. I see them more in the healthcare context. Jason sees them in other industries, particularly IT. And we thought this would be a timely subject to talk about it. We actually have a lot fewer people this week than last week, and we were kind of saying that's probably a good thing. Maybe it's because at the beginning of the coronavirus, we were kind of flooded with inquiries from people that were being laid off and had issues, and it has quieted down somewhat at the firm for the last couple of weeks, and maybe things have calmed down for a lot of other folks. I know there are some lawyers that are on the call today as well who are probably trying as well to figure out what's the best way to advise clients. Some of what we're going to be talking about is pretty clear. Some of it's going to be a bit murkier as far as what the best practices are. But why don't we first just go through some of the major developments for this week to bring people up to date. Probably the big news is on premium processing. So at the tail end, I guess it was a Friday, Jason, that the USCIS announced that they were bringing back premium processing. That was on the heels of some rather startling news that USCIS is apparently bankrupt, and they have been planning a massive furloughing of employees on July 20th. The irony is that this is the agency that's supposed to be punishing people who become public charges when they, in fact, are a public charge themselves. So but premium processing, one thing you need to know is, and that was probably for a lot of people, it's pretty significant that it's available again. It doesn't become available immediately for everybody. There's a phase-in, and it's over 4 weeks that they are bringing it back group by group. I did a blog post on it, so if anybody wants to shoot me a message and wants a link to that, they can do that, or you can just go to scroll through on coronavirus-immigration.com, which is the blog that we have on COVID-related immigration developments. I did a summary of how the phase-in works there. As far as other news, there was some further travel ban news this week. In the middle of the week, Brazil was subjected to a coronavirus travel ban that's similar to what's in effect for Europe and in effect for other countries like Iran and China. Basically, if you have been in Brazil in the 14 days prior to coming to the United States, you are not going to be able to enter the U.S. unless you go to some other country and wait it out for 2 weeks before you come into the United States. Not that there's that much inbound travel to the United States right now, but that's something that was I think people thought that those bans were largely over, and apparently they're not. The other one is the China travel ban, which is the second China travel ban. The first one was coronavirus related. This one is targeted toward F and J students who are working in fields that are or received any kind of funding or doing anything that's perceived to benefit the Chinese army. And it's not really clear how it's to be administered. Supposedly, State Department was going to be gathering a list. That was how it read in the executive order, and now I'm hearing that rather than doing that, what they're probably going to be doing, which is not good news, is just putting people in administrative processing and then doing an investigation after they apply, rather than being able to look at a list and see if the person's on there or not, and not have to unduly delay the person. So if you are dealing with Chinese students, or you are a Chinese student or a researcher, you're going to want to file very early for what you're coming over to do, because you may be facing a long delay with administrative processing. One of my doctor friends who's on asked me to give an update on the 3599 bill and where that is. So right now, it's largely, this is the bill that would create 40,000 green cards for doctors and nurses. And that bill is potentially going to be incorporated into into a COVID bill. There's a COVID bill that already passed in the House of Representatives called the HEROES Act a couple of weeks ago, and we talked about that in the last call. There is also there are bills that are pending in the Senate that are standalone bills that could be incorporated into a COVID bill. So the big issue is what is happening in the Senate as far as a COVID bill. And a couple of weeks ago, it looked pretty bleak that the Senate wasn't going to do anything in that regard. But the economy hasn't improved, and there's a lot of pressure on the Senate. So apparently now they are. And I got word this evening that Republican leadership in the Senate is drafting a COVID bill. So that's very good news that apparently is happening, because if they pass something, they have to reconcile it with the House. And the House has already passed a bill that has immigration provisions in there, including a significant provision for physicians, but a bunch of other provisions as well. So the Senate is going to have to reach some kind of agreement with the House on even if they don't include immigration provisions in whatever they pass, they're still going to have to reach some kind of agreement with the House. So they're going to have to compromise on it. And what I'm thinking is going to probably happen is that 3599, the green card backlog reduction bill, that's the number one bill that's most likely to make its way into the Senate bill. There's also Senate Bill 948, Amy Klobuchar's bill, which deals with Conrad 30 and has green card provisions in there. Both of those are much more likely to make it in than what the House has put in their bill. But the answer is that there is some movement. There were new co-sponsors this past week after there had been a whole flurry of them signing on. If you are a physician on this call and you are not in PAHA, Physicians for American Healthcare Access, please join that group. They are doing great work advocating on all of these bills. And if you want to know how you can help with that, or how your employers can help with that, you can join that group. Okay, so that's the news for the week. So we can move into the topic at hand. As I indicated, this is the subject of the evening is the not very pleasant subject of layoffs, furloughs, hours reductions, salary reductions. And Jason, when we were trying to figure out how to slice and dice this topic, there's a lot of angles to this, and there's a lot of new. I've written articles about this for 20 years. I think I wrote the first time I wrote about this, it was after 9/11 during that recession. Then I took that old article and I updated it after the financial crisis. And I went back and looked at that article, and it was really out of date. There's been a lot of changes in the last 10, 12 years. on it, some good, some bad. So we'll talk about how a few of these things have changed. But I wanted to talk to you first about non-immigrant visas. Probably the number one group of people that are asking questions are people on H-1B visas, professional workers that are here in the United States. And I'm going to assume that everybody on the call knows what these groups are, and what these categories are. So we're not going to get into super basic stuff. But Jason, why don't we talk a little bit about some of the challenges that H-1Bs are facing that are going through some of these changes?
Sure. I think that when you look at non-immigrant visas, the H-1B workers, the E3 Australian specialty occupation workers, and the H-1B ones from Chile and Singapore, that those classes or visa categories are a bit different because they have underlying LCAs or labor condition applications with the Department of Labor. And that's different than other visa categories that don't go through the Department of Labor. And for reasons we'll discuss, I think you can approach differently in terms of furloughs and layoffs and terminations. When you have an LCA, the company has made attestations and it has committed to paying the H-1B worker or the E3 worker, the H-1B1 worker, a certain salary, either by hour or annually, and for that worker to be at a certain location, which is a whole nother topic. But what happens in the context of reduction in workforce is that you cannot just so easily reduce wages or furlough an H-1B worker because of that LCA. So, we have people, I agree with what you were saying, Greg, because, on different listservs and places where immigration attorneys have been speaking over the last few months, it seemed like every day there was a new hypothetical. Well, what if we do it this way? Well, what if we do it that way? Because certainly, if companies are at the point of having to consider furloughs or across the board pay cuts or anything like that, it's not usually because they're flush with cash that they want to then spend on H-1B amendments and a bunch of legal filings, right? I mean, they're usually trying to conserve cash. So, everyone is looking for ways to not file H-1B amendments is I think what was happening. But, what immigration says is if there is a material change in the terms of employment, then you have to amend the non-immigrant visa. And so again, when you're dealing with an H-1B and there's this underlying LCA, the LCA has two wage rates. There's the prevailing wage, which is the wage set by the Department of Labor, and then there's the actual wage, which is the wage being offered to the person by the company. Well, if you drop the person's wage, let's say you want to do a wage reduction, 20% across the board or something like that. Well, if you drop the person's wage and they're on an H-1B and it's below now the actual or prevailing wage, you're no longer, as the employer, in compliance with the LCA. Right. So you almost have a harder time reducing wages for an H-1B worker than you may, certainly for other non-immigrant visa categories, but maybe for other workers in general. I think it sort of cuts both ways, right? The Department of Labor gets involved to protect U.S. workers and to make sure a certain wage is being paid and so on and so forth. But then when you try to make changes to the terms of the employment that the company has attested to, it can be difficult to do that without, again, filing something to amend that. So
if you keep that wage over the prevailing wage, and let's say the company is doing a 10% across the board salary cut for everybody, but that 10% reduction for the H-1B worker, they're still over the prevailing wage, let's just say, then they may not have to do anything in that case because the actual wage has been reduced. So they're not being paid less than the actual wage because everybody's wages were just reduced, not just the foreign worker. And they're still paid over the prevailing wage. So is an amendment, I don't think an amendment is necessary in that circumstance if they're still over the prevailing wage that was listed on the LCA.
Right. I think that's the one way that you could maybe avoid the amendment there. What we have seen more often though is it's not a change in the across the board. You know, they are making companies are wanting to change departments or change certain people's you know, or reduce workforce and you know, changing most H-1B workers' wages does affect the actual and the prevailing wage, and therefore requires an amendment.
So when we're talking about the H-1B workers, you know, the furloughing seems like it's become a very common tactic that companies were using, at least while they were waiting on maybe PPP funding to come in, or just kind of waiting it out until they were, you know, governments were changing their stay-at-home orders to allow businesses to reopen. But you know, if you've got is a furlough any different than a layoff as far as immigration is concerned?
Well, the thing about furloughing an H-1B worker is that you can't stop paying the H-1B worker. There's lots of precedent out there that talks about benching. You can't bench H-1B workers, right? So you can't say, we don't have work for you right now, so we're not going to pay you at this time. Sit tight, you know, until things pick up again, which is sort of the idea of a furlough and maybe a way to treat or a way companies are treating U.S. workers. But with the H-1B worker, you know, that is not really a gray area. We know you can't bench H-1B workers. So if you're going to tell an H-1B worker, we don't have as much work for you this week, you're still liable for the full amount of the salary that's listed on the LCA, right? So you still have to pay that worker the full amount, which sort of goes against the purpose in most cases of a furlough.
Mm-hmm. So we've got so with these furloughed workers, you know, I've gotten the question as well about, well, can I take a leave of absence? Can I take vacation? What are we moving into the gray areas that we were talking about before, or what would you advise if somebody said, well, you know, I just want to take a personal leave?
Yeah, well, I mean, so personal leave is allowed if the employee is choosing to take that leave for a reason, you know, not based on the company. So like you see it with maternity leave or parental leave or things like that. A car accident is like the additional example, and the person needs to be out of work for a little while. But, you know, you certainly can't have the whole data science team decide that they all want personal leaves for the next 3 months, right? So like,
Sure.
I would say you get into the gray area when you start seeing who and why and how many people are taking these leaves. So one person for a short duration for a legitimate reason, sure, but when you're talking about furloughs and groups, then probably not.
Yeah. I've also had people ask me, well, can I just continue working and not get paid on there? I'd rather do that than lose my job on there. And I know the answer to that is pretty clear in my mind, but maybe it's worth your chiming in on that.
Yeah, I mean, I think we're both saying no. Like the LCA to me is there, right? I mean, and again, right, and you have these two sometimes conflicting positions. You have the employer and the employee, and the employer, by not complying with the LCA, can be opening themselves up to risk, you know, and to different liabilities as well. Even, you know, so in some cases it might seem like the nicer thing to do or something like that, but you know, there's the risk of back wages, there's the risk of fines. If you're not complying with the terms of the LCA, there's a risk of being barred from filing LCAs, which could affect, you know, future sponsorship of H-1B workers or green cards in the labor certification process. So there's risks, right? And then on the employee side, there's risks of not being able to prove you've really maintained your status by complying with your H-1B and the terms of the underlying LCA. So, there are risks on both sides of the relationship by not complying.
All right, let's talk about, we're going to talk about some of the strategies people can use when there's like the layoff is inevitable. We'll get to that in a minute, but let's talk about some of these other non-immigrant categories. How about the L1 intracompany transfer? If somebody's in an L1 visa, or L1A or L1B, what are some of the things that you're going to flag for them when you have a conversation with them about the consequences of the layoff?
Right. So, in the context of a layoff, we have similar situations, which I think we're going to talk about next in terms of looking at the grace period and things like that. But you still have issues even on an L1 or an O1 or something like that, or TN. I think in a furlough, I think it is easier in those categories to say we're going to reduce wages, and maybe you could argue that doesn't require an amendment because there's not this underlying LCA, right? So
reduce wages and hours as well.
So I believe that moving someone from full-time to part-time is a material change in their employment. So,
okay. But even if it is a material, let's say that, but it's something that could be amended without necessarily a violation.
Right. But it just requires the amendment. So let's just say you have an L or an O, and they're a full-time employee, but for the next 6 months, everyone's going to go to part-time, or he or she's going to go to part-time. In my opinion, that's a material change because it's going from full-time to part-time and requires an amendment to be filed. If you're just going to say everything is going to stay the same, this person was working 40 hours a week and they're going to continue to work 40 hours a week, but everyone in the company is taking a 10% pay cut and he or she's on an L, I then think you have an argument to make that doesn't require an amendment because, again, there's not that underlying LCA.
What happens if the L company just closes down? I mean, there are going to be companies that don't emerge on the other side of this crisis and shut down, and the company just decides they're not doing business in the United States anymore. What are the options, for somebody in that situation? Because their being in the United States is based on working for a company that's connected to a company abroad. Are they in trouble?
Yeah, I mean, I think so. So, I mean, if we talk about cessation of employment, right? So what triggers a grace period is the ending of employment, and that could be a termination, or it could be the closing of a company,
right.
Or it could be quit.
And we're going to get to the grace period in a second. So you're
okay. So all it is to say is that if the company goes under or something like that, an L1 is not usually in a great position because they don't have a visa that could be easily transferred to another company. Again, like you said, if a person is here on an L based on their prior work experience with a foreign company that is related to the company that then they're here working for, and now there's no company, right? They don't have a relationship to base that on. So, if the foreign parent company has 15 subsidiaries in the US and one goes under and they want to go work for another one and there's still a qualifying relationship, then sure. But in terms of like getting on Indeed and finding a new job in the US, I mean, I think that's a tough situation for an L1.
They're gonna have to find a different visa category for sure.
Right.
All right. Similarly, E1 and E2 visas. Any different advice? I mean, the one issue obviously is if you lose your job with a company that you had based on nationality, then you better find another job with another company that's of a similar nationality, or you're in the same situation as the person on the L. Is that fair?
Yeah, I think that's right. If you're a manager, executive, or an essential employee on an E1 or E2, then that's right. Instead of based on the qualifying relationship, it's based on nationality. So you need to find another, French company if you're a French national. The other thing to consider on an E1 or E2, I would say, is if you are an E2 investor versus employee, and sort of just something to consider is marginality, right? The company has to provide enough financial return for the investor to live, right? It has to provide a marginal living revenue for the investor. So, while I do think it's easier to make the case that it doesn't require an amendment, I don't think it does require an amendment if the proposed salary as an investor in an E2 drops below what is listed on the I-129. I do think you still have to show that there was a marginal income being earned to support the E2 investor and his or her family.
Okay. One group that has where there have been some changes since the Great Recession is in the F1 OPT area, and that group has there's the 1 year optional practical training students, and then there's the STEMs who have up to 3 years of optional practical training. Why is first of all, do they can be unemployed for periods of time in that category, correct?
Correct.
So it's, but I guess the one issue on it is that there's a lot of, it's trickier, I guess, if you're in the STEM OPT, as far as what the obligations are if you lose employment.
Yeah, so an F1 on OPT can accrue 90 days of unemployment in the aggregate. So, that's from the time the person's OPT starts. And then if they are terminated or have been terminated lately, then that clock continues or starts to run. And then if a person is in STEM, you have a couple of things, right? I mean, you have this training plan, right? So there's this underlining I-983 STEM training plan. And on that training plan, the company, again, has made some attestations about the work that is being performed and the way it is being managed and assessed and reviewed. And so if you're going to change the terms of the employment, then I think as an OPT or STEM OPT employer, you need to update the DSO within 5 days of those changes to make sure that they're reflected.
Yeah, and also I think the students have some obligations as well to notify the DSO of changes, even if the company doesn't do it. So it's sort of a dual reporting obligation for them.
So I should say that the 90 days of unemployment goes up to 120 days,
right,
if you're on your STEM extension.
Yeah, so you get some extra time there. So they have a little more flexibility, the students, and as far as that goes. I guess that the other thing that with students is there are provisions in the rules for them to have their hours reduced without necessarily triggering big problems. Although you can't reduce it too much, but you can cut it down to as long as it's over 20 hours a week.
Right, 20 hours.
You can still use it. All right, so let's talk a little bit about some of these. What some of the people that are in this situation, what are some of the options available to them if they're in the layoff situation, or what they might be able to negotiate with their employer. So you mentioned this grace period, and there's always been a grace period for the non-immigrants, most of the non-immigrants, this 10-day grace period that comes at the end of their authorized stay, and they've always had that. They can come in up to 10 days before their work, their start time, and they can stay for up to 10 days at the end. But that's not going to do too much good for too many people. But this other grace period that you were mentioning is the 60-day grace period, and that was something that we've only had since the beginning of 2017. In fact, it was like in the last week of the Obama administration, I think, that rule took effect. So the 60-day grace period, tell us a little bit about what that is and what it isn't.
Right. So at the point that employment ends, certain visa categories under the high skilled workers rule that you mentioned in 2017 now get a 60-day grace period. So those are E1s, E2s, E3s, H1Bs, H2Bs, H3s, L1s, Os, Ps, and TNs. So it's most non-immigrant visas are now entitled to that grace period. And what the grace period, I mean, it was a really big change, right? Because what previously happened, if the person was terminated, the next day they were supposed to leave the US, and they were essentially out of status. Now you have this grace period. So at the date of termination, you start a 60-day clock that the person can stay in the US legally. They just do not have work authorization. So terminated H-1B, if terminated on June 1st, has the next 60 days, essentially June and July, to be in the U.S. but can't work. But during that time, he or she has a number of options. The most obvious one would be to look for another employer, right, to pick up the H-1B. And so if you find another employer and that person files an H-1B transfer during the 60-day grace period, you can begin work with that new employer and never have departed the U.S. like you would have had to before the grace period came about. So, I mean, that's a huge advantage, right? 2 months to sort of figure that process out and get something else filed. Now, that's obviously 2 months seemed like a lot more time when unemployment was at 3%, than maybe 2 months is right now. And so for people who are in the position of in their 60-day grace period and trying, and the clock is ticking and they're running out of time and haven't found new employment, what we see a lot of people consider is filing changes of status to that of a B2 visitor. So, I mean, the important part is that while you're in the grace period, you can file another petition from within the U.S. without having to travel. So that could be a change of employer, or it could be a change to another status. So, I mean, maybe you change to a visitor status, so you have 6 more months to stay here. Again, not authorized to work, but to be here legally. Or, I think we might see, depending on how much the U.S. Upsets foreign students, but we might see some people who, go back to school. So maybe they switch to an F1 or something
Very
like that.
interesting you mentioned that, because we have a question in the chat about whether somebody can legally start taking classes and then file to change status to F1 during that grace period. So sounds like that's something that would probably be okay.
So, so first of all, like, you have to preface everything with the university with, like, ask your DSO, right? Because every school gets to sort of decide how to do these things on their own, and there's not always consistency across the board. So baseline golden rule, ask the DSO when you can start studying. But I mean, the answer is probably, because an H-1B, a person on an H-1B can study, and a person on an F-1 can study. The issue is that a change of status in the U.S. from H-1B to F-1 or H-1B to B2 or anything else cannot be premium processed and is going to take a very long time if filed here in the U.S. It could be 6 to 12 months to get a decision on that change of status. So, if it is safe to travel and if you are able to travel, it would be much quicker to go to a U.S. consulate in normal times, get an F-1 visa, return to the U.S. and start studying on your F-1. But again, if the DSO will agree that you can start studying an H-1B status, I mean, I think that is right that you could do that.
So, all right. And there was a second part to this question as well, which is, are you eating into your 6-year time limit on the H-1B while you're in the grace period, for example, or while a change of status application is pending? What does that do if you are, if the clock is ticking toward the end of your 6 years on your available H-1B time? I mean, I think that you can make the argument that as soon as the termination happens, that also tolls the clock, that the grace period doesn't eat into it because you're not authorized to work during the grace period.
Right. It's a really good question. I haven't actually seen that question before. I would make the counter argument that, when it comes time to recapture unused H-1B time, they're going to look at your I-94s and your entries and exits to the U.S., and the I-94 record is going to show that you were here during those days in H-1B status, even if not working. So,
but the employer's notified USCIS, and you have the termination, and they've notified them. So, I mean, one could make the argument that it's over.
I think you could argue both ways, and I haven't actually seen a decision on, that I'm aware of that.
All right. We're getting a question about unemployment compensation. I'm going to get to that in a little bit as far as questions go. So hang on to that thought. All right, Jason. Another common strategy over the years has been to file a change of status to put somebody in a visitor status. And the argument that we used to make was that looking for a job is a permissible visitor activity. But in recent years, there's been some pushback from USCIS that that's an acceptable visitor visa activity. What's the current thinking about filing for a change of status? I mean, we used to do these also because it was fast to file that, and somebody could get terminated in the morning. They used to be instantly out of status on the date of termination. So we would basically file that application immediately, and sometimes beg the employer to give us a couple of extra days so we can get that application filed. Well, what's your thinking these days regarding changing to a visitor status, especially because it's an application you can file online?
I think there's two ways to think about that, because where my mind immediately goes and what people have been saying to us is, okay, even if I wanted to leave, there are no flights home, right? I can't go home even if I want to. I don't have the ability to travel. My flight's been canceled 6 times, whatever, right? So, I mean, even if looking for a job might not be the greatest argument for a change of status to B2, the inability to leave the United States and get to wherever it is you're supposed to get is a really good reason, right? And so we see lots of people that are filing changes to B2 status for that from all sorts of different categories. Some of which based on termination of employment, and some of which not based on that reason. So, I mean, I think given the circumstances right now, it is a legitimate filing. I think what I've seen the most RFEs and things like that on changes to B2 usually have to do with the ability to support yourself while you're here. So anyone who's going to file a change to B2, number one, you need to be able to support yourself while in B2 status, for the 6 months you're requesting, but you should also submit evidence of that. So bank statements, savings accounts, whatever it is you have.
You might have gotten some severance money.
Right. Yeah, for sure. So severance as well. Whatever you have to show that you're going to support yourself while not working for the next 6 months is really what I concentrate on submitting with the application.
Right. And we talked about it a little bit already, but it seems like in a lot of cases, sometimes people can negotiate with their employers and may be able to negotiate a reduction in their hours as well as their salary and just cross the line. So that's also potentially an option for people. And it is worth noting that H-1Bs are available for part-time employment. So in a lot of cases, if an employer still needs you for, I've certainly seen this in the physician context, where there have been physicians who they are still needed by their hospitals. There just is not the demand for them to be employed full time. So that's also probably worth mentioning for any doctors that are on the call, that there was a memo a couple of weeks ago that came out from USCIS where they noted that a reduction in hours does not automatically mean you're violating your J1 waiver program rules that normally require you to work 40 hours per week. However, so the good news is you're not going to get the 2-year home residence requirement reimposed on you. You still need to amend the H-1B that you're working on to reduce the hours, and you're not going to get credit toward your 3 years of service that you need while that's going on, but it's better than the alternative of either being out of status or having to leave the country and being resubjected to the home residence rule.
Right.
Yeah.
And to add to that, the idea of part-time employment. So if there's an option of reduced hours versus termination, and the company has accepted, okay, we're going to file an H-1B amendment, but we're going to take the person from full-time to part-time. One thing to consider is that in part-time employment, you do not have to say specifically the person's going to work 17 hours per week, right? You can list a range. So once you've said it's not full-time employment, it's part-time employment, it could be 10 to 20 hours a week, or 5 to 20 hours a week, or 1 to 10 hours per week, or whatever is. I mean, the range has to be justifiable, and you may have to explain why that range makes sense. But, right, to take someone from a full-time position with an annual salary of X, right, that's a pretty rigid situation to be in. But if you take them from that to 5 to 20 hours per week at an hourly rate, that may be a flexible position for the company to then be in and to see how the next 6 months or year or whatever go. And that person's, still employed and still on their H-1B.
Good. All right. Well, let's change subjects and let's talk a little bit about permanent residency processing, because there's a completely different set of issues there, particularly with folks that are going the labor certification route. So if you have somebody that is in the middle of a perm process, what are some of the issues that need to be both in terms of their being laid off and also the company having layoffs, but maybe the foreign worker doesn't get laid off, but there are layoffs going on at the company. So maybe you can talk a little bit about some of the issues that come up in that context.
Right. So perm, or the labor certification, tends to be a pretty in the weeds topic for people who don't spend significant time in it. But hopefully most people are familiar with that being a test of the labor market to determine whether or not there's a U.S. worker who's willing, qualified, and able to fill the position that the foreign national is going to fill at the time they become a permanent resident or green card holder. So what happens is that after you go through the Department of Labor and you recruit, and it comes time to actually file the labor certification with DOL, there's a question of whether or not there has been a layoff in same or similar positions within the last 6 months at the company. So a lot of companies, have been saying no for a really, really long time. It's almost, you don't even think about the box as you go through at the company. But now a lot of companies may have to say yes. And what that means is, if there has been a layoff in a similar position, you actually have to notify the employee that was laid off. Because what the process is supposed to do is determine whether or not there's a qualified, willing, available U.S. worker. Well, if you just laid someone off in a similar position, there may be. And what will happen in practice is, when you reach out to the laid off U.S. worker and say, by the way, we have an opening for another software engineer, just like you were, with similar experience and requirements, education requirements, they're very likely to say, well, yeah, I'll take my old job back, which, is going to stop the recruitment from being, successful, so to speak, and proving that there weren't any workers willing and able, and that's going to stop that perm process. So the practical effect of layoffs is that it could likely stop perms for the company for 6 months in those positions.
Okay. Let's say you made it through. You got your perm, and your I-140 is pending, and then a layoff happens. So that seems like pretty clear that you're done with if you haven't actually gotten the I-140 approved, correct?
Right.
So that is one of the places right now. If you think that a layoff might be coming, premium processing has just returned. So that might be your first priority, is to upgrade that I-140 to premium processing and get that approved as quickly as possible if you think there's any danger that there might be layoffs down the road. Although, even if you get the I-140 approved, it's got to be approved for a period of time before you really get the benefits from the 2017 regulation, which maybe you can say what that regulation did regarding locking in your priority dates.
Right. So
it's so important to have it pending for have it approved for 6 months or more.
Right. So, I mean, I will say this, there's one benefit to having your perm and your I-140 approved and then being laid off, and that is extending your H-1B beyond 6 years, right? So if you get an approved I-140, and particularly for the person who was asking questions about being at the end of their 6 years, if you did get an approved perm an approved I-140, and now you're laid off in your 5th or 6th year of H-1B time, you now are eligible for unlimited H-1B extensions, right? So that's great. You are not eligible, most likely, for completing the green card process if that's where it ends, because what Greg is mentioning is portability.
Well, locking in that priority date so that you, so that you don't have to, you get at least some credit for the time that it was since you started the process.
So that's another benefit of the approved I-140. If the I-140 is approved, you have locked in your priority date and you have made yourself eligible for H-1B extensions beyond 6 years. In terms of taking the green card with you or benefiting from the green card application beyond those ways, in terms of permanent residence, you need the perm to be approved under the 2017 memo. You need the perm to be approved. You need the I-140 to be approved, and you need your adjustment of status, your green card application, to be pending 6 months.
Right.
So it's not really until the 6-month mark of the pending adjustment of status that the person becomes, quote unquote, portable. And then even at that point, the person needs to port or change to a job at another company that is the same or similar. And so what USCIS tends to do to determine that is look at the responsibilities or the job duties and try to see if the person is spending at least 50% of their time doing the same thing. They also put a lot of emphasis on the SOC code, just another sort of in the weeds thing, but the Department of Labor category that classifies the job. But if you have been, if you're a software engineer again who did perm I-140 adjustment of status is pending 6 months, and you are then porting to a new employer, moving the H-1B, you could revive that green card if you're also again in a similar software engineering role, as an example.
Yeah. Well, and one thing that you and I talked about before the call about, we weren't quite sure how to approach the topic is, we do have this benefit that not a lot of people know about, and most immigration lawyers probably haven't never even filed one, which is a compelling circumstances EAD if you have an approved I-140. That's in the 2017 regulation. We don't know, there's not a lot out there in terms of experience. If you, if you get 20 lawyers in a room, you may find a handful of them who have any experience dealing with that, and it's probably pretty limited. We don't have any statistics from USCIS on how many of these that they've granted. We don't think that there's a lot, and all we really have is sort of the preamble to the regulations, but it's something that you could try. So if you are in this situation, you can demonstrate that you have you were laid off, you have a good story to tell as far as the, that your circumstances. Maybe you can show that, it's reasonably likely you're going to be able to get reemployed at a certain point. That maybe your industry is temporarily shut down, or maybe like this would be a good one probably for people that work at hospitals where they can show there's a very limited defined time that they are going to have problems. But the remedy is out there. So it might be something worth putting on the list to see if you can get it. Certainly during that, if you think during the 60-day grace period that that's not going to be enough, it might be worth trying to see if that, file an I-765 and seeing if you can get an EAD on that basis. But you have to have an approved I-140 to get that benefit and it's super discretionary on the part of USCIS.
Yeah, and it's only available for certain categories, right? H's, E3s, H-1B1s, L's and O's. It's not available for everyone. And then another thing to sort of think about in the practical pursuit of a compelling circumstance EAD, I think would be the timeline to just get an EAD.
Mm-hmm.
Right? Just that, in many cases it's taking 100 days to 180 days to get EADs. And so you also have to balance maintaining, a status in the U.S. with the just slow wait times.
Sure. All right, let's change the subject again and talk about unemployment compensation, because that has been a big issue this go around versus I think a lot more, probably than 12 years ago. So basically, and I had to go back and do some research on this because this is not something that immigration lawyers think that much about as far as qualifying for unemployment on there. But there has been, and there have been some organizations out there that have done some good writing on this. So basically, you have to have, to qualify for unemployment, you have to meet the same requirement as U.S. workers. And that means you have to have lost your job through no fault of your own. So if you were fired for, if you were fired for coronavirus, you're in good shape. If you were fired for, performance issues or something like that, you're going to have a harder time. And employers sometimes have an incentive to say you were fired for something else because it affects their unemployment insurance rates. So then you also have to show that you were earned wages during the base period, which is generally the last 12 to 18 months. That's very possible if you were working on an H-1B visa, et cetera. But you also have to be, quote unquote, able and available to work. And this has been a hang up for people that are on visas that are employer specific. So it seems like the question was regarding a person with an H-4EAD who's currently furloughed. I think they would actually have an easier time filing for unemployment because as soon as they find a job, they have a work authorization document that allows them to begin work immediately. So I think somebody in that situation has a shot at it. The H-1B spouse is going to have a harder time based on the way I read it. There's some of the research that I did on this issue seem to indicate that TNs were okay because there's an ability to get a TN without wait by just going to a port of entry and coming in immediately, and that there had been some lawyers that were reporting success in getting their clients getting unemployment compensation when they were in the TN status. But I think you have to have something like that. So I think categories that have employment authorization documents like spouses of E's and L's and H4s, maybe OPT might have a shot if they're in STEM OPT where you can show that you were working in the previous 12 to 18 months and you still have a work card that allows you to continue longer. Of course, you can't stay on unemployment that long or you're going to violate the OPT rules for that. But so you get into kind of the weeds in a lot of these tricky issues. But it is something that's it's available to some people. So, I think there's a blanket assumption that non-immigrants are never eligible for unemployment compensation, and that's not really true. Some may be. So it's certainly, I think, worth looking at that.
I agree. I think the H-4EAD is a good example, or just anyone with EAD, right? Maybe an asylee, or maybe someone with a pending green card application. Because I mean, again, if you have a valid employment authorization document, that sort of, in my mind, takes care of the are you able and available to work question versus the H-1B worker. And I think anyone on a non-immigrant visa really that's tied to a company is gonna have issues, though. Like you sort of said, unemployment in general is sort of outside of what we normally deal with. And there are also state law issues depending on where the person's located. But I do think the valid EAD is the strongest argument.
Well, and one related issue in terms of in terms of new things that we're seeing this year. So the timing was almost like uncanny, where this public charge rule went into effect in just in the weeks right before the COVID crisis was starting, and that's one that people are starting to ask questions about. How does the public charge rule affect you if you have been in a wage reduction, hour reduction, layoff situation? And maybe you can talk a little bit about what the public charge rule is and what, and we can talk a little bit about maybe where people can get tripped up in it.
Right. So the new public charge rule is an expansion of what was already a public charge rule, right? Which was a question of whether or not the intending immigrant would likely become a public charge or likely become in need of government assistance. This was traditionally cured either by showing the income or assets of the petitioner, or in the employment-based context, the person's salary and income there. And what we have seen now with this expansion under the Trump administration is that they are taking a really, really expansive view in what is a public charge. So it's not just, and again, I was going to say is that traditionally that it was cured in that way, or it was cured by the signing of a form that USCIS created that was an attestation that, if the petitioner was unable to support the beneficiary, the foreign national, then this signatory to the affidavit of support would step in and provide that financial support. And despite it being a contract with the government that they drafted, they have sort of stopped believing or having faith in their own contract, and then taken this big expansive view on who is likely to become a public charge. And to do that, they have made a list of benefits that could make a person a public charge. And they're also looking at way more factors like education and credit score, assets. They're looking at who else is in the home and their financial stability or financial health, and other considerations like that. They're looking at whether or not the person has health insurance. So it's really
good point. If somebody loses their health insurance because they lost their job, that's going to be a problem with public charge.
Right. And is that the same if the person is 65 and 25? Right. I mean, in the consideration of public charge, right? Like in determining whether or not the person's likely to become a public charge. I think we do know that collecting unemployment, is not necessarily a trigger for a public charge finding. Right now.
Right. That we know. That's not considered a benefit, unemployment.
Right.
So I know we're clear on that. What about those CARES checks that everybody was getting?
Also not a determinative of a public charge finding, right? So those were the things we know trigger public charge findings. One, they were supposed to have listed, but also they were based on findings of need, which is different than temporary circumstances of unemployment.
Right. Well, so you mentioned credit reports, and you have credit scores and credit reports. So obviously, if there's a deterioration in your credit score, that's potentially a problem. Bankruptcy and foreclosure,
problem. But let's just be clear that it's sort of like a scale, right? These are negative factors in determining whether or not the person is a public charge. It does not just mean they are a public charge, right? So you could have a foreclosure, but still have, I don't know, the assets in some other way.
Right. Or if you find a job even after you've had the foreclosure, and you can show that basically whatever was causing that financial distress has passed, then you're all right. So, within the public charge, there's these highly negative ones that are basically really hard to get past. And that would be, for example, like public benefits on there if you get them. But, dings on your credit score, that's something that you can probably overcome. Income in the household is also one that they look at. So if it's, if you're applying at a point where nobody's working, you're going to have a problem. But if you had, you had a dip in your income, say when you're providing your tax return, but you've now found employment and income is up. So they're basically they'll look at stuff in the past as a possible indicator that you're likely to become a public charge in the future, but you can overcome that by showing what your current circumstances are.
Right. And so I think it's also in thinking about public charge on a very case-by-case situation, how likely was this person or this household, what factors were already there before furlough or termination, right? And then in the current circumstances, how long does that unemployment go on for, right? I mean, if is the person unemployed for a month and then finds an equally paying job a month later, right? Like that seems hard to believe it would be that negative a factor. But if terminated and going on for a long time without unemployment leading up to the adjustment of status interview, I mean, that could be a lot more complicated to explain.
All right, so we've covered the bullet points that we had on our list of things that we wanted to cover tonight regarding this subject. We've answered a couple of questions that people have had. If anybody has questions that they want to ask, then they are welcome to they're welcome to type the question and ask. You're also welcome to email Jason or me. My email is gsiskind@visalaw.com. Jason is jsusser@visalaw.com. You can find us on our website, visalaw.com. And I also have I'm finished with it. I'm waiting. I'm doing a little cleanup, but I've just have a fairly in-depth article on the subject we were talking about tonight that I'm putting the final touches on. So I think we will probably send it out maybe to folks that signed up for this call. If you're not interested, you can just delete it, I guess. But that's it for tonight, unless we have questions, and I'm not seeing any.
Greg, we had like a couple questions that had come.
Oh, yeah, advanced questions?
Yeah, so
go ahead. Yeah, why don't you go ahead and address that?
Yeah, so one of them was about a person, I believe, who filed a change of status to R1 while in their H-1B grace period, so while in the 60 days after the termination of their employment. And it was whether or not they were in status or they needed to leave the U.S. That was the question to answer. If the R1 is pending, so it was filed before day 60 and is pending, then the person is here legally. They're in an authorized period of stay. What happens next will depend on the organization. So with R1s, you have a site visit, which can take quite a while to get. If the organization has previously had a site visit, then you could upgrade to premium processing now that it's returned. If they have not previously had a site visit, then you would need to wait for the site visit to happen, though you are waiting here legally. And then once the site visit happens, you could upgrade to premium processing. And there was another question here. I was terminated while in H-1B. Should I report USCIS that the employer needs to pay my return home? And we didn't mention this.
Yeah, that's a good thing. I mean, we should have mentioned that, but it's a good point to use now.
So, right, when an employer terminates an H-1B worker, they basically have three obligations, right? So they need to withdraw the LCA. They need to notify USCIS that the termination, that they're no longer employing the H-1B worker. And number three, they need to offer return home travel, expenses to return home to the H-1B worker. That is a requirement of employing people on H-1Bs. In my experience, a lot of people don't actually take the offer, but you do have to offer it as the employer.
And you also you also are on the hook if you don't notify USCIS that you've terminated a worker. USCIS will require you to pay those wages. They'll consider it back wages that you owe that person. And I've seen some employers in recent years who didn't do that, and one in particular had a six-figure amount that they ended up having to pay somebody because they never did it, and the person the person was threatening to file a complaint, and they had the law was on the employee's side in that case, so the employer just settled with him.
Yeah. So if you are an employer, you must do three things, right? Withdraw the LCA, notify USCIS, offer return home to the employee. Someone had a question here, and Greg, I don't know if you might be able to answer this. They asked if we think there would be spillover to EB2 India because of the executive order. So, I assume they're talking about the suspension of some immigrant visas being issued at U.S. consulates and embassies abroad. Do you have thoughts on that?
Um, yeah. So it's and we talked about this a little bit this last week. So the answer is yes, there's supposed to be a spillover for whatever family categories family preference green cards are not adjudicated by the end of this fiscal year. The way it works is when every family-based number that's not used in a fiscal year rolls over to the employment category for the following year, and every employment number that's not used in one of the preference categories rolls over to the family numbers. And there will be because of this executive order, about 95% of the family-based preference green cards are processed at U.S. consulates, and most of those are barred, as well as the parent's immediate relative category. So there's nobody who knows exactly how many we're talking about, but I know some people who think about this a lot think that the number is probably as many as 120,000, which would be a near doubling of the employment numbers. Well, 120,000. Let's say 120,000. So basically, what will happen is that on October 1st, they will recalculate the green card numbers that are available for the fiscal year 2021 that starts October 1st, 2020, and they'll be looking at, instead of 140,000 green cards, they'll be looking at 260,000 green cards. In each category, like the EB1 category gets 28%, and EB2 gets 28%. So they'll be looking at 28% of 260,000 rather than 140,000, which should be, mean that the employment-based numbers move a lot faster next year. The caveat that I have for that is that I'm not a big conspiracy theory guy, but we've already seen some evidence that the State Department is putting pressure to play political games with the visa bulletin, and they should have advanced the family-based categories for this year for people that were still eligible to apply, people in the United States, for example, people that had, Mexican family-based cases in particular, and they didn't move those numbers at all. I am not going to believe that the State Department is going to advance the numbers for the employment categories until the October visa bulletin rolls around, and we actually see that happening. I'm very suspicious that Stephen Miller and some of the folks in the White House who have big problems with employment-based green cards, as well as any of the categories, that they're going to advance those, let those numbers advance. So we'll just have to see what happens. Jason, we have another question in the chat room. They're asking whether we're going to be speaking on OPT, proposed changes to OPT in an upcoming meeting. So this is in reference to this executive order that might be coming the next week or two. We will devote our subject for the Zoom call immediately after that executive order to that subject. We will also be doing a call on DACA when the Supreme Court decision comes out on it. So, we will be covering those big subjects in the news, and we'll probably pair it up. It depends on how long we think it's going to take to cover that subject, whether we do another one as well. But the idea is we're doing these every week, so we're going to try and cover a broad variety of topics. Our firm, we have we are a larger immigration firm than some others that are out there, and we have lawyers that work in all kinds of areas. So we have the ability to cover a lot of different kinds of subjects for these calls, and we will. So thank you to the questioner for that. We did have the person who asked us questions before regarding the grace period and whether the H1. So the question was whether that's H1B status.
I wanted to add something to that question. Sorry to interrupt, but so, I do think you are in H1B status in the 60-day grace period. And I'm not sure if we said this earlier, but your grace period is 60 days or the end of your I-94. So if you're on an H1B here, and let's say your I-94 ends 30 days, then you don't get 60 days, you get 30 days, because the I-94 controlling your valid status in the US is only 30 days. So you get the lesser of 60 days or the time remaining on your I-94. So for that reason, I would say you are still in H-1B status.
Now,
Because
but that may be a different question than whether you get those days count, those days count toward the 6 years.
Totally. But I think what this person's now asking is just whether or not that's H-1B status, which it is because of the I-94, and because if you file a change of employer, then, right, we know the person can port and start working at a new employer on H-1B by filing a change of employer during the grace period.
Right.
So I think it's a separate question what the other person was asking.
It's an interesting question because I don't think the USCIS has like really gone into any depth as far as saying how that works, but it might be it might be it's the same person. It might be worth keeping an eye out and seeing if USCIS decides to address that at any point. There was a follow-up question regarding the 120,000 extra green cards, whether they would be subject to per country limits. So to follow up on that, so let's go back and let's say, and I'm not sure it's 120, but let's say that EB1, for example, we go from 28% of 140, so there's 40,000 normally in EB1. Let's say that now there's going to be 70,000 that are in EB1 because of this increase in the numbers. So the way it would work is that right now EB1, the 40,000 is mostly used up and on there, but there's probably not that much more demand for EB1 than for 40,000. So there's going to be a lot of leftovers. The leftovers would then go to the people that are in the per country caps. So if those 30,000 are not being used by rest of world in EB1, they would then go to, the answer is that initially it's subject to per country caps. So 7% for India, for example, out of the 70,000 is the way it's going to calculate it first. So it's a slightly bigger pool than 7% of 40,000. But the big gain is going to be on the leftovers for rest of world that then go to the per country folks, and then whatever's not used. Let's say there's not enough EB1 Indians, even after those 30,000, and there probably are, but let's just say there weren't. Then there will be a spill down to EB2, and then a spill down to EB3, and then they spill up. It goes back up to EB1 again. But anyway, the point is, if you're Indian and you're then you should probably you should see the double bump, 7% of an increased pool of numbers overall, and then an increased likelihood that there's going to be leftover numbers in that category that are going to spill over to you a second time on that. So I do anticipate, if the State Department follows the rules, that there will be significant advancement of in the lines for people subject to backlogs, which is obviously good news for those folks. Not so good news for the family immigrants who never got their green cards in the first place, and that's a whole different story. And there's also litigation filed by various groups and individual lawyers trying to do something about that, although the time is ticking. So once the clock runs out on to September 30th, if those green cards aren't issued, then I don't see any other way. I don't think there's any legal way around it. So we'll have to see. It's something certainly to watch. I think we've used up our questions. So we appreciate your joining us this evening. This call has been recorded, so we will be putting the video up on our website. And I think Jaleesa in our office posted last week's call today on there. So give us a couple of days to get this. We have to do a little editing, and we have to get it converted in I don't know how she works her magic, but this should be in about a week. It should be available. If you have suggestions for topics you would like us to cover in future video calls, send them to us, and we're looking for ideas. And thank you very much.
Thank you, everyone.
Good night.